Welcome back. This module covers something that most people who try to get into real estate investing never take the time to understand, and it shows in how they talk about what they do. I want you to understand it completely, because when you understand the legal foundation of what we're doing, you can explain it clearly. You can defend it confidently, and you know exactly why it works. We're talking about the bundle of rights. If you have the training guide, this is the property rights module. Follow along if you have it in front of you. When most people think about buying real estate, they think about buying a house, a piece of land, a building. That's technically accurate, but it misses the most important part of what real estate ownership actually is. When you purchase real estate, you are not just acquiring the physical land and structures. You are obtaining a legal concept known as the bundle of rights. Think of it as a bundle of sticks. Each stick is a separate legal entitlement. You can hold all of them, share some, sell some, or transfer them individually or all together. That flexibility is what makes every creative real estate strategy possible. Leasing, seller finance, assignments, joint ventures, all of it flows from this one concept. The bundle generally contains 5 core rights. Let me talk through each one. The first is the right of possession. You are the legal owner. You have the right to occupy the property. This is what most people mean when they think of owning a home. It transfers at closing when the deed records in your name. The second is the right of control. You have the authority to manage, renovate, or use the property as you see fit, provided you comply with local zoning laws, building codes, and any HOA rules. This is the right that allows us to renovate a property after we acquire it. The third is the right of enjoyment. You have the right to use and enjoy your property peacefully without interference from others. If something nearby significantly disrupts the enjoyment, an industrial facility, a nuisance neighbor, environmental contamination, you may have legal grounds for recourse. This right affects property desirability and is relevant in every acquisition analysis. The fourth is the right of exclusion. You can decide who is and isn't allowed on your property. You can prevent trespass. This right has limits though. Easements for utility companies, law enforcement with a warrant, but it established that you are the one who controls access. The fifth, and the most important one for what we do, is the right of disposition. You have the freedom to transfer your ownership interest to others. You can sell the property outright, you can gift it, you can lease it, you can include it in your will, and you can assign your contractual right to purchase it before you ever close. Hold on to the last one. I'm going to come back to it. Before I explain why disposition is the key to wholesaling and all real estate investing in general, I want to make sure you understand that these rights are rarely absolute. Encumbrances can take sticks out of your bundle. An easement gives a third party the right to use part of your property, a utility corridor, an access path. A lien, like a mortgage, a tax lien, a mechanic's lien, represents a financial claim against the property that has to be resolved before a clean title can transfer. Governmental limitations apply regardless of what you want to do. Zoning laws, environmental regulations, building codes, taxation, and eminent domain gives the government the power to acquire private property for public use with compensation. Private restrictions, HOA covenants, and deed restrictions run with the land. Every future owner is bound by them whether they agree to them at purchase or not. Always check CC&Rs during the due diligence phase. And individual rights can be split and sold separately. Subsurface rights, oil, gas, minerals, can be sold while retaining the surface rights. Air rights can be sold to allow development above the property. A leasehold transfers possession and enjoyment while the owner retains legal title. Understanding these limitations is critical when you're evaluating any acquisition. Always ask, what encumbrances are attached, and how do they affect what we can do with this property and what we can offer for it? Now, back to the right of disposition, because this is what makes wholesaling legally sound. Here's what actually happens in a wholesale assignment, step by step. Step 1. A property owner signs a purchase contract with an investor. In our case, through the work of an acquisition associate working with Tobin LLC. When that contract is signed, the seller has agreed to exercise their right of disposition, and the buyer, our side has acquired what's called an equitable interest, a contractual right to purchase that property at the agreed terms. That equitable interest is in itself a property right. Step 2. The investor identifies a second buyer, an end investor who will ultimately purchase and hold or renovate the property. Step 3. The investor assigns the purchase contract to the end investor for a fee. That assignment transfers the equitable interest, the right to purchase, from the investor to the end buyer. The investor is not selling the property. They are selling their right to buy it. That is the assignment. Step 4. The end buyer closes directly with the original seller. The seller exercises their right of disposition and transfers the full bundle of rights to the end buyer. The end buyer is now the legal owner. And step 5, the investor collects the assignment fee. That fee is not a real estate commission. A commission is paid to a licensed real estate agent for brokering a transaction on behalf of a buyer or seller. An assignment fee is the consideration paid for the transfer of a contractual right, a property right. Those are legally distinct, and that distinction matters. Here is a simple way to think about the structure we use. Imagine two friends who decide to buy, fix, and sell a house together. One finds the deal, does the legwork, and gets it under contract. The other puts up the capital and manages the transaction. When it sells, they split what's left. Neither is an employee of the other. Neither is representing the other. They are collaborators on a shared opportunity, each contributing something different. That's what a joint venture is, and that's the relationship that governs how acquisition associates work with Tobin LLC. The bundle of rights is what makes it possible. The right of disposition is what makes it legal. When you understand this, you can walk into any conversation with a seller, an agent, a buyer, or an attorney and explain exactly what you're doing and why it works. That confidence is worth more than any script. This module is in your training guide if you want to review the key terms and the full breakdown. I'd recommend going through the terms section in particular, especially the distinction between equitable interest, legal title, and assignment fee. One more thing before we close. Different states may have their own requirements and laws governing wholesaling activity. What might be legal in one state may not be legal in the other. Be sure to seek legal counsel. I'll see you guys in the next video.